Welcome all friends from India and from other parts of the world. Once again, joining us in overwhelming numbers, and we have audience from all over the world, from Brazil, Colombia, Netherlands, New Zealand, and I'm really surprised at how much traction this sessions are. We have about over 900 people joining us today, 950 or something like that. I don't know. But a large number of people have joined. Registrations have been exceeding every day. And it's been very exciting to share whatever little knowledge, experience, and our thought process are with you all. It's really very exciting. Today we have a discussion on tax policy, public international law, and its interaction with bilateral investment treaties. And Mr. Clive Baxter and Professor David Rosenbloom, both will be, talking to us. And I would like Parul to take over the reins and introduce them a little bit, and we move forward. So I think you will thoroughly enjoy. Both of them have huge experience in cross-border taxation and global policies and, academia, as well as the practical experience. So welcome, Clive, and welcome, David. Over to you, Parul.
Thank you, Nishith Bhai, and really warm welcome to all our participants, and warmer welcome to our guests, Clive Baxter and David Rosenbloom, who are well-known authorities, in the space of tax literature. Today's topic is going to be really interesting and very exciting to talk about. We will be talking about the world of bilateral investment treaties, and Professor Rosenbloom is going to talk about how he thinks and whether he thinks BITs can be invoked for the purposes of resolving treaty disputes. We are already aware that Vodafone and Cain, at least in the Indian context, have both invoked the bilateral investment treaties, and we have to see how that goes. And in the meanwhile, India has also terminated most of its bilateral investment treaties under the earlier models. But we'll talk about that more. We are also going to have a very exciting discussion on the advent of an international tax system. And Mr. Baxter is going to, he's contributed a chapter to Nishith Bhai's book on public international policy and where does international tax really fit within the whole realm of public international law. And, there are a lot of developments that have been happening over the last few years, specifically, with respect to OECD's BEPS project. But does the OECD really become the new world tax organization, in his own words? Does it lead to a new world tax order? I will not take much time talking about these things, but hand it over to our guest. Professor Rosenbloom, maybe if you could just go first and tell us a little about the chapter that you've written on bilateral investment treaties and your views around invocation of the treaties in a tax treaty context.
Delighted to have the chance to write in honor of Nishith, who's an old friend. My chapter is on bilateral investment treaties, and really it's also about tax treaties. I had the opportunity, I guess that's the right word, to serve as a witness in two actual bilateral investment treaty arbitrations. And as some of you know, I have a long history with resolving cross-border tax disputes. I've served as a witness in lots of arbitrations, lots of cases. I'm in the process today of writing my 30th expert witness report. But I had not previously been involved in a bilateral investment treaty arbitration. And frankly, I came away from the experience slightly appalled. I had no real knowledge of how these disputes were addressed. But my experience with both the law and the process of a bilateral investment treaty left me feeling quite strongly that this was not the right way to resolve a tax dispute. Whatever other kinds of disputes might be adequate, might be appropriate for a bilateral investment treaty, a sophisticated tax matter is not one of them. And that's for a whole variety of reasons. First of all, the standard that's applied, the fair and equitable standard, that is the general standard, I think it's the dominant standard in a bilateral investment treaty. I find that to be so broad as to be virtually meaningless and very, very difficult to understand how to interpret that with respect to a very particular tax dispute. And so the standard itself struck me as really problematic. Secondly, the intrusiveness of the process into the sovereignty of a country strikes me as very, very deep. I mean, you have people who aren't from the country talking at considerable length, I'll get into that in a moment, about what the country should have done or might have done or what its constitution requires. All of that struck me as hugely inappropriate. I frankly do not understand why a country would submit to that in the tax area. I'm not sufficiently, I can't talk about other areas, but for a tax matter, it strikes me as a very poor choice. And let me say at this point, in my piece for Nishith's book, I put in contrast to bilateral investment treaties the mutual agreement procedure under tax treaties, and particularly mandatory arbitration, of which I am a big fan, having been very close to that process now for 10 years. The objections to mandatory arbitration are usually framed in terms of sovereignty and in terms of surrendering the sovereignty of the country. And, you know, it strikes me as weird that a country that would object to mandatory arbitration, which, if it's done correctly, has very minimal intrusion into the sovereignty of a country, would allow this hugely intrusive process of a bilateral investment treaty. Now, the other problem with bilateral investment treaties that I encountered is that, as far as I can tell, in at least the case that I saw two cases, no one really knows much about the subject. So you've got a bunch of people flailing around trying to figure out what this very vague standard means in relation to a set of facts that they have no expertise. I'm not denigrating them. They're very fine people, the panelists, the lawyers, etc. But they're dealing in an area that they don't know anything about. And to my astonishment, in one of these hearings, I was in a room with, there must have been 60 people in the room, and I and my associate were the only two people in the room, as far as I could tell, who knew anything about taxation. So it strikes me as a very, very strange process. Also, it is very expensive. The bilateral investment treaty arbitration that I personally attended went on for 2 weeks, hour after hour after hour. And I thought each of the sides had 25 hours to argue, which is frankly nuts. I mean, in the United States, in the highest level Supreme Court case, the lawyers don't get more than an hour on each side. So 25 hours is forever. And so there's no restraint that I can see on what the lawyers can say or develop. And without restraints, they spend hours listening to themselves talk. Frankly, I was just appalled. The cost to a country of this has got to be huge. You had a room full of people and very sophisticated equipment. It just struck me as a huge waste and just a very poor way to get to a resolution. Also, I might add, the time for a decision, because the record in these cases goes on for volumes. I mean, many, many volumes. And the time for a decision runs into years. So it's not an efficient process. It's not directed toward a reasonable resolution. And I did not realize that India had terminated so many of its bilateral investment treaties. I'm not privy to the considerations of the government in doing that, but it strikes me as just a very poor way of going about resolving tax disputes. I think that a country that really wants to resolve tax disputes ought to put its attention into the the mutual agreement procedure. And frankly, it occurred to me that all countries coming out of this pandemic are going to want to know how to promote investment inside their borders. And in my opinion, the single best thing that the government of India could do to attract investment into India, and I have direct experience outside the bilateral investment treaty area with investments into India, the single biggest thing they could do would be to pay serious attention to the mutual agreement procedure and mandatory arbitration. An announcement like that would be huge for people seeking to invest in India. Because if there's one thing that deters investment in India at this point, it's the whole process for resolving disputes. Now, I know there are all sorts of arguments against that, but I can't see a country that has entered into bilateral investment treaties saying, oh, no, we can't do mutual agreement procedure because that's too much of an intrusion into our sovereignty. So I'm going to stop there. I don't know. I hope I haven't exceeded my time. My position is really very simple. I saw this process up close, very up close, way too up close. And I was horrified, frankly. And the idea that any country would subject itself to this and at the same time turn its back on a process which is efficient, which is very low cost, in my experience, the mandatory arbitration procedure, which is fair, and the whole purpose of which is to get resolutions without ever having an arbitration. I just don't understand the thinking. So I'm going to stop here and let others talk. Thank you.
Yeah, just to intervene for a moment, David, thank you so much for this opening remark. You know, what happened as a consequence of being sued by over 20 foreign investors on reneging on the investment regime. India terminated almost 60 investment treaties and tried to adopt a new model of bilateral investment treaty. In fact, India lost case in one of the early cases, and then after they thought that, you know, there's something wrong because they couldn't stand to that. And then one after the other, number like Vodafone, Kane, many other cases that have come up. So about 20 cases are against India, and India wanted to protect itself. So they have revoked those treaties and now trying to figure out what next to do. So, you know,
Parul had told me that. I hadn't realized that. I mean, in my view, they shouldn't have entered into those treaties in the first place. I have nothing against the treaties as such. It's the treaties covering tax matters that bothers me.
Yeah, understood. So,
right, sure. And, you know, Nishith bhai, since you mentioned this, I would also, you know, like to say that in the new model bit which India has adopted now, tax is expressly excluded. And in fact, when India terminated 58 bilateral treaties in 2017, there were 25 other treaties which had not yet, you know, finished their initial period. So they try to enter into joint interpretative statements with those countries, stating that, you know, it is clarified and implied that tax was never meant to be part of a bilateral investment treaty. Probably it was all an outcome of the Vodafone and the Gain, you know, disputes which went into arbitration. But before we move on to Clive, and although we have a separate Q&A session, David, but since I read your chapter with much, you know, interest, as always, your chapters are always like that. You also talked about the Vodafone dispute and specifically retroactivity. And, you know, you gave your thoughts on whether retroactivity can actually be a reason to invoke a bilateral investment treaty. So maybe you can just touch upon that. I'm sure that's going to be really, you know, it's going to be a good conversation for our audience.
Well, I think we're going to get off on a lot of tangent if we do that, but let me just say two things. I have read Vodafone probably as closely as anybody on this WebEx program. I've read it repeatedly. I've studied what happened. I think the law prior to Vodafone was certainly not clear. And I think, therefore, there's no question, and I say in the article, there's no question Vodafone was retroactive. But the retroactivity, although nominally to 1961, in my opinion, was for about 5 months. The time of retroactivity was between the Vodafone decision of the Supreme Court and the act of Parliament effectively revoking it. And I do say in the article that I find that retroactivity, insofar as Vodafone itself is concerned, because they were the Supreme Court litigant, I find that to be a different matter from the question of other parties. on retroactivity generally, we have had 7 Supreme Court cases in the United States challenging retroactivity on constitutional grounds, and on every occasion, the Supreme Court has upheld the government position. The court has often said that they disapprove of retroactivity. Retroactivity is problematic. There's no question. There's a lot of rhetoric out there, but the facts are that retroactivity is pretty common, at least in my country. And as I've said repeatedly, the Tax Cuts and Jobs Act, which we passed in December of 2017, had some seriously retroactive provisions in it. Now, they may get challenged. There is a challenge. I haven't followed where it stands out in Washington State. There may be a challenge on that, but I will be very surprised if our courts ever find any kind of constitutional flaw with retroactivity. And by the way, retroactivity exists in a lot of other countries as well. So that's my view.
Right. And we'll come back to that conversation later during the Q&A. But, just moving on to Clive. Clive, probably, if you can talk about your chapter and, your whole thoughts of an international system of taxation. So please go ahead.
Hey, thanks very much, Parul. I'll now see if I can manage to share my presentation. So, the article I wrote for the book in honor of Nishith Desai's 70th birthday covers a few topics, all really to do with the developments in international tax and how they fall into the context of public international law.
Clive, can you be a little loud?
The right button.
Can you be a little loud?
Let me.
Yeah.
Let me. Has this made a difference?
Yeah.
Better? Okay. So what I'm going to talk about is the emergence or possible emergence of the public international law of taxation that we're seeing happening before our very eyes, so to speak. I'm putting in here the great questions of life. And where did we come from? We came from tax arbitrage. And what are we now? We have the BEPS recommendations, the MLI, the updated Model Tax Convention. We have peer reviews. And where are we going? Are we going to World Tax Organization? Are we going to customary principles of international tax law? Where is this brave new world that we're heading into? So where did we come from? And you're allowed to smile at this slide. This is a figurative slide. And on the left, you'll see the CFO of an MNE. And he was alone in the world and subject to higher withholding tax in country S than other MNEs. But on your right, his in-house tax manager consulted with a beguiling tax consultant who you'll see in the top middle and offered a fruitful proposal to the CFO. And on my next slide, you will see the forbidden fruit that was offered to the CFO. So this is the age of treaty shopping. And a few words on treaty shopping. It's a legal technique and using intermediate companies to eliminate inconsistencies in host country treatment between nationals of different countries. And interestingly, it's known from the area of bilateral investment treaties and trade agreements as well. And I'm not sure actually where this started, but it's certainly well known in those areas as well as within tax. And the investment treaties and trade agreements, they have this clear primary objective of removing discrimination and opening markets, removing barriers to trade. And if you look at this from the point of view of business, treaty shopping, I'm saying. The idea was to obtain most favored nation treatment. Business in one country didn't want to be treated less favorably than businesses in another, and not being able to resolve that through the bilateral tax treaties, that people started using the intermediate company, holding companies. And it sort of moved on from there. So when I sort of presented in this way, it all sounds fairly innocent and harmless. So, you know, what is our view? Should we have a level playing field with tax treaties so that tax residents of one country should not be treated worse than residents of another? And if you look at the World Trade Organization, that is absolutely the main principle of all those agreements, is that nobody should be treated worse than anybody else. And if we look at the Model Tax Convention from the OECD, it talks about removing the obstacles that double taxation presents to developing economic relations. But then we have another aspect, and that's that the bilateral tax treaties take into account the unique features of the systems of the two countries involved in their political relations. So the tax administrations are generally not inclined to grant treaty benefits on income that's going to escape taxation in the residence or the home country. And they're also aiming at reciprocity in fiscal effects. So now we begin to sort of see why the OECD, G20, and a whole host of other countries decided that they wanted to do something to address this issue of treaty shopping. And if you look in the treaties, you will find examples where there will be relief in the source country and no taxation in the residence country, but there will usually be conditions attached. And you know, the collective investment vehicles and pension schemes are examples of those kinds of conditions. So now a few words on tax arbitrage. And stating the obvious here, taxation principles, they're a legal construct. There's no self-evident natural law that says how a tax system should work, or how we should be taxed, or how much we should pay. And you know, unless human nature changes, you have to have some sort of enforcement mechanism. Otherwise, nobody's going to pay tax, or at least not very many. And then touching a bit on what David Rosenbloom was talking about, the right to enact taxation rules and enforce compliance on residents within the sovereign territory, these are considered to be one of the key characteristics of sovereignty. So this is why countries are very reluctant to give that up in any way. Yeah, I think why a lot of them are hostile to the idea of a binding arbitration. As a consequence of this, most domestic legal systems ensure two things. One, that tax can only be levied on the basis of legislation, because there is no sort of natural law of tax, so there has to be a specific law. And the other one, that payment demands from foreign states will not be enforced in the national legal system, the revenue rule. And these were principles that you could find in pretty much every country going back in time. But as business became global, these two features opened the doors for tax avoidance and evasion. And I'm going to show you a couple of statements by a couple of well-known judges from the US. We have Judge Learned Hand, the man with the most wonderful name, who said that anyone may arrange his affairs so that his taxes shall be as low as possible. Nobody owes any public duty to pay more than the law demands. And we have Lord Tomlin from the UK 2 years later saying every man is entitled, if he can, to arrange his affairs so that the tax attaching is less than it otherwise would be. And this is about the same time that we have the League of Nations looking at how tax treaties might be formulated, and the four economists and all this. This is all the same period in history of tax law. As we move towards the year 2000, there are already some voices saying that we should have a public international law of taxation, because there were concerns about taxpayers being able to avoid taxes by exploiting the gaps between the different national tax systems. And in 1986, we had the US Senate referring to an international tax system while they were discussing perceived treaty abuses by dual resident companies. The OECD had started its harmful tax project and published reports on conduit companies. There'd been one attempt to promote a multilateral tax convention dealing with substantive cross-border tax issues. And interestingly, this was under the auspices of UNESCO and the World International Property Organization. And this was for the avoidance of double taxation of copyright royalties. And it was a complete failure. It's never entered into force. There are actually 9 countries which have ratified it, one even quite recently, but nothing came out of it. And in 2000, Professor David Rosenbloom, whom I did not realize when I was writing my article, I might end up on the same panel with him, but in 2000, he argued forcefully that at that time, there was no international tax system that could prevent cross-border tax arbitrage. There was no multilateral document, and there was no pronouncements from national tax regimes suggesting that there was a common understanding of what the international tax system might be. And then the bilateral tax treaties, which is what Professor Rosenbloom recognized as being part of international law, they lack the leverage to strike an international tax arbitrage. And they did. And this is what the BEPS project has been trying to do something about. And what I'm going to talk about for my remaining minutes is whether BEPS is just improving the bilateral tax treaties, or whether it's also creating this overarching international tax system. So, where are we now? And as we can see, Moses received the 10 Commandments, and the OECD received the 15 BEPS recommendations from Pascal Saint-Amand and his team. And the OECD was saying that the integration of economies, globalization, has put a strain on the international tax framework, and there was a need for a bold move to restore confidence. Key concept underlying BEPS, in my opinion, is the concept of single taxation. And in the introduction to Action 15, relating to the MLI, it says that BEPS relates to instances where the different tax rules lead to double non-taxation or less than single taxation. Now, single taxation is a rather simple principle that all income should be taxed once and only once, but it's anathema against tax arbitrage, because if income falls into the gaps, then the single taxation principle says you have to move the boundaries so that the gap disappears. Part of this development that's currently ongoing is that we've seen artificial avoidance, which was spoken about a lot by politicians, NGOs. It's actually become a concept in international law because it's part of the preamble MLI. This means that some, but not all, legal techniques that used to be used in tax planning won't be effective. And I'll say a bit about that later, because BEPS is not preventing all forms of tax planning, because we're still allowed to avoid double taxation, thankfully. So, you may remember Judge Learned Hand, and on the earlier slide we were missing his little sentence, "Don't celebrate before I pronounce my judgment," because after saying every man, etc., had a right to pay as little tax as possible, he then said, looking at the particular case and the facts in front of him, the transactions are no part of the conduct of the business. There was no commercial reality, and the taxpayer can't avoid her just taxes, and she has to pay. So what he was saying about nobody has to pay more tax than the law demands, yes, but he was also saying that you can't artificially avoid paying the tax that the law says you have to pay. So that was a surprising twist in the tale. So the MLI, a vision of heaven for the single tax principle, and the OECD said that it would swiftly implement the treaty measures, updating the over 3,000 current tax treaties instead of renegotiating them all. 94 countries have now signed up for that. So this really sounds a very major breakthrough. But back to Earth, yes, it was signed in 2016 and entered into force in 2018 generally, but only for the individual countries when they ratify. And if we look at the Vienna Convention, Luxembourg ratified in 2000, Brazil 40 years later in 2009. The US never ratified. So, you know, we could be looking at up to 40 years for all the countries to ratify. Said, I just checked the other day, 44 countries have ratified, and that's quite a remarkable achievement in the space of 3 years. Still 50 to go, but that's quite remarkable progress. Part of the BEPS project, the MLI, is the Action 6 on treaty abuse. And there, interestingly, they're saying that the previous situation where we had gaps between domestic laws and even in the context of the bilateral tax treaties, that this was undermining tax sovereignty by allowing taxpayers to claim treaty benefits where not intended. So in a sense, countries have to give up some of their individual sovereignty to get back the sovereignty that they were losing in this globalization context. And we have things like the new preamble to bilateral tax treaties mentioning tax avoidance as one of the objectives, and the limitation of benefits and principal purpose clause coming in. As a minimum standard, now you heard just before that there are 94 signatories of the MLI. There are 137 members in the inclusive framework who are all committed to implementing the recommendations. Now they can do it through the multilateral instrument. If they don't go that way, they have to go another way. One of these, the principal purpose test, this says that treaty benefits will be denied unless the benefits would be in accordance with the object and purpose of the provisions of the treaty. And this can either come in via the MLI, Article 7, or by including the model provision from the latest OECD convention in individual treaties. And the objects and purpose, just a couple of words about that. When I saw this, I thought, this is just nirvana for tax lawyers, because we are now making tax benefits, tax treaty benefits contingent on being in compliance with the object and purpose, which is one of the most debated and elusive legal concepts in treaty law. And it first appeared in a judgment from the ICJ on the Genocide Convention in 1951. And 5 of the learned judges dissented, and in their dissenting opinion, they said the test of compatibility with the object and purpose of the convention is so difficult to apply. So, if it's difficult for the ICJ, I think there's prospects of many disagreements and disputes arising on that part of it. So where are we going with all this? This is where we are. We have the BEPS recommendations. We have some changes in law. We have the MLI. We have the NTC. Do we now have an international tax order under the OECD G20? Is it now a fully fledged branch of international economic law? Is even a customary international obligation to observe this principle of single taxation? Well, I'll give you a few thoughts on it, and let's see what we think in the discussion afterwards. The statutes of the ICJ mention 4 principal sources of international law, or actually 4 sources, including international conventions, which would include bilateral tax treaties, and interestingly also the MLI, but also international custom as another source of international law. And if we look at the international legal system, we have human rights, and we have world trade, various other areas of international law. What do they look like? What do these tax systems look like? Well, typically, you'll have a multilateral treaty with wide coverage. If we look at the international tax architecture, we have the MLI. Okay, it's not comprehensive in respect of international tax, but it does have a wide membership. There may be another MLI coming next year, following the OECD's Pillar 1 and 2. You would see an international organization with depository monitoring, advisory and enforcement functions. is this the OECD as the secretariat for the OECD 20s inclusive framework, functioning as a World Tax Organization, cooperating with the UN, IMF, and World Bank Group? It's not thinkable. I'm not sure that we're completely there, and maybe we won't get there, but we might do. Resolution mechanism, well, we have MAP, and regarding the interpretation of the MLI, we have the meetings of the states. Many multilateral treaties actually don't have a compulsory dispute resolution. It's quite often optional. Some have several different choices. And then again, we're going to have the Pillar 1 MLI, dispute resolution mechanism, potentially. Again, often the key principles of the multilateral treaty codify law or capture emergent principles of law, which was the case with the Vienna Convention on the Law of Treaties. Now, the single taxation principle, the principal purpose tests, which I've misspelt there, I can see, are these emergent principles of customary international law? I think they're candidates. So, the last few slides, the ICJ identified some hallmarks for emerging customary law in their North Sea continental shelf judgment. So I'm going to apply these tests to single taxation and the anti-avoidance principles of BEPS Action 6 to see if we might be approaching these hallmarks, which incidentally in that particular case, the particular rules certain countries were saying were customary international law, the ICJ decided they weren't. But here we have the tests, and these are the last slides. So, a fundamentally norm-creating character forming the basis of a general rule of law. Well, I would think that a general rule of single taxation could qualify. It will typically be the primary obligation rather than a second choice. And again, if we look at Section 3 in the MLI, that minimum standard, it's not an optional one. And again, although possible, it's not likely the treaty would allow making a reservation. Well, you can make a reservation to Article 6 and 7 in the MLI, but only if you have similar provisions in your covered tax agreements. So I think that is pretty clear that those principles are ones which you cannot decide not to follow. You're going to sign and ratify the MLI. Widespread and representative participation, well, 94 if all the countries ratify. The VCLT itself only has 116 parties, and again, including the states whose interests are especially affected. Well, we have the states most affected except the USA, and interestingly, the USA is also not a party to the VCLT. Seems to be generally accepted as customary international law, or at least parts of it. And in the case of the MLI, it would seem the absence of the USA is compensated by their own practice. Another hallmark, the passage of time, and time factor is not so important according to the ICJ. So if the other hallmarks are met, then the treaty abuse provisions could qualify in a short period of time. So the state practice should be extensive and virtually uniform. Well, here we see the US has actually implemented the treaty abuse provisions in the MTC at the latest in the 2016 version. EU's issued its anti-tax avoidance directive, and many countries are implementing via the MLI and treaty protocols. So we're seeing a lot of state practice and a lot of states who are especially affected. And again, China and India, I think, are very significant in this respect. And it should occur in a way to show a general recognition that a rule of law is involved. And we're seeing a lot of statements from G20 leaders suggesting that there is a duty to have these kind of regulations. Now, the US might disagree, but again, it's an objector is not necessarily a hindrance to principles becoming customary international law, assuming these are isolated. And in fact, in this case, the US is not wanting to sign up to the MLI, possibly for domestic reasons, but is not persistently objecting at all to most of the principles. Now, Pillar 1 might have different history. We shall see how it develops. And again, we see a formal peer review process going on. So I think this could be satisfied. Again, there's no inference that customary international law has arisen just because these are following the principle. So what we've seen so far is perhaps not sufficient. Because they also need to show a belief that this practice is obligatory. So the fact that the US has also brought these provisions into the 2016 model, that's not enough. You know, if the US practice is to be evidence of a customary international law, then the US has to believe that there's a legal obligation to do this. I'm not sure that's the case. But if we look at the peer review system and the recommendations, and if countries continue to comply and implement the recommendations. Slide. Yes, yeah. Sorry about that. I've just moved the microphone. Yeah, the last slide. And again, if you look at the exchange of information, assistance and collection agreements, which cover most of the world these days, the revenue rule also seems to be not really part of modern practice. So I'm concluding that it looks as if we're moving towards a customary international law of tax, but Pillar 1 and Pillar 2 are probably a very critical test, and particularly if the US pulls out of Pillar 1, then this whole project might end up carrying a lot less weight than it will if Pillar 1 and 2 are also successfully concluded. That's it. I'm ready for questions.
Thanks a lot. Thanks, Clive. I think you've raised some very pertinent questions, with respect to where we are moving, where an international system of taxation is concerned. And of course, we'll have to watch the developments to really come to an answer to that question. But moving straight away into the Q&A round, and we'll just talk about the bilateral investment treaties a bit more. Although we discussed that India has terminated, about 58 of its treaties, and taxes excluded from, from the new model bid. However, we did have a white industries case, and this white industries case was actually one of the reasons why India also terminated its bilateral investment treaties. The issue in this case was, with respect to enforcement of an arbitration award, which was won by an Australian company. And interestingly, the award could not be enforced for almost 10 years. And White Industries finally invoked the India-Australia Bilateral Investment Treaty. What really happened in that case was, there was an MFN in the India-Australia Bilateral Investment Treaty. Using the MFN, the Australian entity relied on the India-Kuwait Bilateral Investment Treaty, and stated that there was no effective means of asserting claims and enforcing rights. And this is a provision which was borrowed, from another bilateral investment treaty. So, David, looking at this kind of an experience, do you really think, and we've heard your vocal thoughts on why bilateral investment treaties should not really be used for resolving tax disputes, and you gave us your thoughts even on the Vodafone dispute as well. But can extraordinary delays in resolving tax disputes, and it's not new that there are delays in resolving tax disputes in India. Can that be a reason that a country has failed to, to encourage and promote favorable conditions, or can a judiciary's actions really amount to a denial of justice and lead to an action against a bilateral investment treaty?
I basically don't think so. I don't think that's an appropriate response. I mean, if the courts of a country are not adequate to resolve a dispute, it strikes me as somewhat irrational to put the dispute in front of three people or however many people who are not from the country and don't know anything about the dispute. It strikes me as an irrational approach to dispute resolution. I mean, I actually have been in India. I've consulted with the government in the past about how to resolve the huge backlog of disputes. And there's even within the borders of India, domestically, there are things that could be done. That's another whole topic. But I do think that I'm much more inclined to think of the world than Mr. Baxter as being a world of individual nation states. And yes, it's a globalized world, but I think my own sense is that we've gotten out ahead of ourselves in terms of our belief that we have some kind of global system here. I think countries still act very much in their own interests. I think that's what we're seeing now. I think frankly, that's what we're seeing even in the OECD discussions, which I don't have much. I'm pretty skeptical about myself. But to come back to your specific question, the problems with dispute resolution in a given country, and I hate to always talk about India, but since we're talking with many Indians on this WebEx, India has had historically a lot of problems with that. And it seems to me that if India would pay attention to resolving disputes within both domestically and in a cross-border way, they could do a lot of good for the investment climate in India. I've said that already. But going to a bilateral investment treaty is not a formula for success. They take too long, they're too expensive, and they're phenomenally inefficient. That's the whole point that I'm saying. That's my point.
Right. Sure. Thanks. And you've talked about mandatory arbitration and how if there is a mandatory arbitration, that's the fastest way to resolve disputes. And in your view, if India would really reconcile to a mandatory arbitration methodology, that may really boost investor confidence. If we look at, there's a peer review report of OECD of 2019, which has come out, and it contains certain statistics with respect to how successful India has been with respect to the MAP program. Of course, the data is till 2017, and India is time and again showing its commitment to resolve the MAP cases within a period of 24 months, while right now it is lagging behind. And most of the cases which are getting resolved are with respect to most of the cases are with respect to attribution and allocation cases, which are taking lesser time as compared to the other cases which could take even north of 60 months. But on an average, the cases are taking about 36 to 38 months, and India has committed to bring down that number to 24. How, given your experience, on the dispute side, how feasible do you think this will be? And if this really works out, then also is mandatory arbitration really going to be required with the peer review process going on?
Let me be very clear, Parul. The whole point of mandatory arbitration, the entire point of having a provision on mandatory arbitration, is never to have an arbitration. The whole point is to put pressure on the process. It's great for India to come, and I have direct knowledge of the Indian competent authority process. I've been involved in it for years. India's made huge improvements in that, huge improvements, and my hat's off to them. But the fact of the matter is that mandatory arbitration keeps pressure where it belongs, which is on the competent authorities to get together and do their job. And I fully accept the idea that there's a commitment by the government to improve the time, but mandatory arbitration really would improve the time. We have actual experience with that, particularly with our neighbor to the north, Canada, with which we've had lots of problems over the years. They put in mandatory arbitration in the US-Canada treaty, and at first there was some hesitancy on both sides. But my impression is that process has been improved tremendously by the existence of mandatory arbitration. You don't need to actually have arbitrations to count mandatory arbitration a success.
Okay, thanks. Just moving on to the whole discussion around international tax systems, and Clive, you talked about the MLI being regarded as a customary law in the future, even though given that it could, and in your analysis it could even take about close to 40 years for countries to ratify the MLI. With respect to the Pillar 1 proposals, which are yet to be finalized, OECD seems to be saying that it's on track to finalize the digital tax proposals by 2020. There are still a lot of unilateral amendments which are being done by many countries, India included. And possibly the biggest issue is with respect to the formulatory approach, which has been provided by OECD, which may not be accepted by a lot of countries. Given this, and maybe US may not be the only country to have, given its pushback on the Pillar 1 proposals, but there are other countries as well. Given this, what are your thoughts on OECD really taking up the role of a world tax organization and for everyone moving towards a truly global tax system?
Okay, I'll take the last part of the question. Is the OECD becoming the World Tax Organization? And I think the answer to that is yes and no. I think that the OECD G20 and the inclusive framework, the 130 countries, I think that de facto has become the World Tax Organization, and their secretariat is the OECD. And I think that this is on the back of success of the BEPS project, which I think has surprised a lot of us with actually how far they got and how much agreement there's been. And again, we still, if the Pillar 1, Pillar 2 negotiations, for whatever reason, should fail, then I think that would be a big setback for the OECD. I think we would probably see maybe the UN or the IMF trying to step in instead. But let's see if they can keep everyone together. They've taken great care, as I said, even though the US would not sign up to the MLI, they have made sure that the final BEPS reports and the MLI provisions are actually compatible with the US domestic regulations and their model treaty. And it's clear that a big demand from the US side is that their guilty regulations, that whatever comes out of Pillar 1 and Pillar 2, and particularly Pillar 2, needs to be consistent with the US guilty regulations, because I don't think the US is going to rewrite guilty just because of Pillar 2. So, and I, of course, agree with David Rosenbloom that yeah, this is a collection of individual countries. But I do think, and particularly when you look at the people that the OECD got involved in the MLI projects, where you know they actually brought in the world's leading experts in public international law and arbitration. They brought them into the project. There's just a lot of indications that they actually really are trying to set up an international tax system and move towards a world tax organization. Is that where it's going to end? I don't know. See. There's another question of whether that's good or a bad thing. Leave that to the politicians.
Okay. Okay, thanks. David, would love to get your comments also, you know, from the US side, you know, specifically the whole debate around the digital tax, you know, proposals. And with respect to Clive's, you know, thesis on moving towards an international tax system, you've also talked about tax arbitrage in your, you know, your really, you know, prior lecture in, I believe, 2000. So would you really want to give us, you know, some inputs on where the world has moved in the last 20 days and the comments you made on the tax arbitrage issue in your lecture? Do those comments hold true even as of today?
Wow. Well, that takes me back 20 years, Parul. So yes, tax arbitrage. Let me. Boy, I don't even hardly know where to begin. Let me start by saying that I think BEPS was a big success, and I agree with Mr. Baxter that BEPS was surprisingly successful. But I'm not sure that I agree with what BEPS actually did. I'm not sure we would agree on exactly what BEPS accomplished. To my way of thinking, the success of BEPS was in bringing international taxation out of the closet and onto the front pages of the world's newspapers, so that you've got literally millions of people who can spell international taxation today, which wasn't the case during the majority of my career. So international tax is a front page subject and has been for some time and probably will continue to be a front page subject. I think the arbitrage stems from the fact that tax systems are national systems. And inevitably, and I've written about this many times, inevitably countries are going to come to different decisions about how their tax system should work. And I'm talking about the really fine points. And what's happened, not only have we had a globalized world, but what's not been written enough about in that globalized world is the ease of communications. Look at this WebEx. We've got people from all over the world talking about very sophisticated things. Those people, frankly, when I started my career in international taxation, didn't exist. You couldn't find out what the tax system was in Peru from one moment to the next. But if I got a question today, I would be on the phone to Lima in 10 minutes and I'd have somebody of equal sophistication who could answer my questions. I mean, the world has gone a long ways. BEPS contributed hugely to that. I'm a skeptic on Pillar 1 and Pillar 2. I've written about being a skeptic. I think trying to change the international income tax system to accommodate digital taxation is just misguided. I think what ought to happen, if countries want to tax on a source basis, if they want to go after the high-tech companies, there's nothing to stop them. They can put in place value-added taxes, they can increase value-added taxes, or for that matter, they can put in place gross basis withholding taxes. but changing concepts of arm's length and changing concepts of permanent establishment and having the world go along with that, to me, that's a bridge too far, and I just don't think it's terribly desirable. So bottom line, I still think tax arbitrage exists. I am not at all sure that I know that BEPS took a swing at it. I'm not at all sure how much that's going to work, but that remains to be seen. We won't know that for 15, 20 years as to how successful that's been. On digital, my preference would be to say countries should do what they want to do. You know, if France wants to tax Facebook by imposing a value-added tax, or for that matter, even a withholding tax on advertising revenues, by all means, that's a decision for the French. I don't see why we need 134 countries to decide. And I might add, as a final point, this whole exercise has a little, from a U.S. perspective, has a little bit the flavor of having the rest of the world get together and take a majority vote as to what the U.S. tax system should look like. And I frankly don't think that's going to work.
Thanks, David. I think that's a very interesting and stimulating discussion. Clive, I think you also had a couple of questions for David. Maybe if you want to pick them up, this could be the right time. Specifically, I think the one which you had on the map. Maybe we can have a discussion around the purpose of map.
Yeah, but I'll just add a last comment. The digital, because I think that the problem with a national approach to it is that if you have Facebook making money by, let's just say, a Canadian company paying Facebook to show adverts to people in France, France can't put a withholding tax on that payment, and they can't easily put a VAT with the international system. I think that's what's driving it. Although again, I do agree that there's certainly a risk it's all going to end up falling apart and in a free-for-all, and that would seriously dent the position of the OECD as well. Yeah, on MAP, and I think my question, which I think is actually getting to what David said, is the purpose of having MAP or compulsory or binding arbitration, which we've had in the EU in transfer pricing for many years, and there've been hardly any arbitration cases in the EU because the countries have all settled. Because the last thing they wanted to do was have a panel of people from other EU countries deciding how the taxing rights should be, or the taxable income should be allocated. So I would agree very much with Professor Rosenbloom that the whole point of mandatory binding arbitration is not to go to binding arbitration, but it's to focus of the two competent authorities to make the effort to reach agreement. And this is not just a problem with India. It's not just a problem with developing countries. I've seen cases between OECD countries where the two competent authorities have just walked away from each other and couldn't agree, where there was no mandatory arbitration. But David, did you have more thoughts? Because I think you actually answered my question with what you said earlier.
Yeah, I had noticed your question. I think I may have jumped the gun on that, Clive. Let me just say that our most difficult treaty partner to deal with is Canada. That's been true for decades. There's a lot of reasons for that. There's a lot of history, and there's a lot of mutual contact. And our relationship in the mutual agreement procedure with Canada had declined substantially over the years. And the adoption of mandatory arbitration has been, I think, a tremendous improvement in that relationship. I have a deep investment in that relationship. I negotiated the U.S.-Canada Treaty for the United States. I really would like to see it work, and I think it is working much better with mandatory arbitration. And I really, truly believe that the objections to mandatory arbitration are way overblown. And to my way of thinking, they're because people can't get their arms around how simple a process it really is. It's remarkably efficient. It's not very costly. It's very quick, and it's very rational, and it achieves results. And I do absolutely believe that in the right set of circumstances, we've had mandatory arbitration in effect with France, with Belgium, Germany, France, and Canada since the 2004, 2005. No arbitrations, to my knowledge, with Belgium, France, or Germany. I had a case when the Belgian treaty was changed to mandatory arbitration. I had a case that had been pending for 8 years. We got together with Belgium and settled it in 4 months once the mandatory arbitration went into the treaty. That would happen. I think that would happen. Countries got to be prepared for that. The real intrusion into sovereignty in the tax treaty world is entering into a treaty in the first place. I mean, what's the point of entering into a treaty and saying, oh, but I don't really want this to work? That doesn't make any sense to me. If you're going to have a treaty, it's to resolve double taxation and maybe non-taxation in the modern world. I don't object to that either. But you enter into a treaty to make it work, not so it's just some showpiece of how you belong to the international community. Those are my thoughts. We don't have enough time in this conversation to go into all my thoughts, however.
Yeah, no, thanks a lot. I think just yeah. Sorry, go ahead, Clive.
I was going to say, I'd say here to that, and I'll just briefly share. I actually had one experience with investment treaty arbitration, but that was actually a case where there was no tax treaties. That was all there was. And the company where I worked that time, we then went to the arbitration route, and the result was that we achieved a settlement compromise. The country in question, they didn't want to go to arbitration in the end, and so their minds were concentrated so that they found a solution that was okay for both parties. And I'll just share with you that, and I agree absolutely with Professor Rosenbloom's impression of the bilateral investment treaty type of arbitration panel. It was a strange, I said, it didn't start because we settled, but we did all the preparations, and I was a witness, and I was put through a course of witness preparation by these investment treaty lawyers, which involved me being analyzed by a jury consultant. And at the time, I'd actually just seen the film The Runaway Jury. I don't know if you've seen it, but Gene Hackman is a jury consultant who goes around blackmailing and doing all kinds of unpleasant things to the jury. So I was quite relieved I didn't have to appear as a witness in the end.
Yeah, thanks a lot, Clive. And I think just my small 2 bits here, are that in any case, when India has entered into bilateral investment treaties and, arbitration has been accepted as a mode for resolving disputes, then there does not really seem a reason why, India should not really accept mandatory arbitration. But we are running out of time. But before we hand it to Nishith Bhai, I just want to get Dhruv in, who has, very nicely edited this book for Nishith Bhai. And Dhruv, just your 2 bits on this issue, and if you have any questions for our guests here.
Well, thank you very much, Parul. Actually, sorry for being late on this WebEx. My 2-year-old daughter was taking all my time away. But actually, my question was more on the point when Professor Rosenbloom talked about rewriting the domestic laws of 134 countries is, of course, going to be problematic, and that was a great understatement. To my mind, I have a question for Professor Rosenbloom. Don't you think the OECD should be focusing its attention on how to restrict what countries are inherently trying to do in order to capture digital taxation rights within the digital economy? And there are certain things like the equalization levies which are unacceptable. Don't you think they should be working out ways in which they lay down the contours of what countries may do? Forget about how they do it, like what tax treaties generally do, which restrict domestic law. So if the OECD can come to an acceptable solution as to how to restrict whatever countries want to do in order to tax within the digital economy, wouldn't that be more effective rather than trying to rewrite the domestic laws of 134 countries?
Yeah, I have no objection to the OECD trying to bring some degree of harmony to the taxation of digital commerce. I just think that the idea of doing it through the net income tax is a bad idea. I think it ought to be, if the OECD wanted to concentrate on indirect taxation, which strikes me as the most appropriate way to deal with this, that would be fine, and have a conversation along those lines. But it seems to me that, to quote a famous British poet, their reach has exceeded their grasp here. And I just don't think we're going to get any kind of agreement on changing the taxation laws of all these countries. By the way, my own country would be we'd benefit hugely if we changed our law. I think we ought to change our law, but it's not going to happen. It's not going to happen in our lifetime. It's just not a possibility. So I think the world ought to get more realistic about what is doable. And I do think seeking harmony in the article that I've written with a colleague, Peter Barnes, the suggestions we made were to look at indirect taxation for digital or look at gross withholding taxes. And if something slips between Mr. Baxter's suggestion of the Canadian company with showing with French clients, I'm sorry, we're not going to be able to correct everything in this, and reaching to do it is going to we're going to end up having nothing. It seems to me that's, I think, the likely outcome.
Okay. Great. Thank you. We've just run out of time, and I will just hand over the mic to Nishith. Nishith, before you start, we are getting a lot of questions from our participants, they are asking us when this book is going to be available to the public. There are a few people who have written saying that, during this lockdown period, they should not be deprived of an e-copy. So please, your comments on, when can people really be, and, actually one of the students, she has written specifically saying that, please, don't do this to us by not giving us an e-copy. So Nishith, please tell us when this book can be available, so that everyone can hear it from you, and then your closing remarks, please.
Yeah, thank you so much, Parul. To answer our last question, first of all, Amazon is responsible for bringing out e-copy. I don't have control over them, even though we deal with them on this subject. So we have actually requested that they were indicating in a week's time. They also got into a little bit of trouble because of the lack of resources. So while I think within a week or so it will be available, and as soon as it's available, we will write to each one of you that the book is available. In the meanwhile, if you want, you can just write to us about your interest in the book, so we can specifically also come back to you. But that is my answer to your last question. Now, I hope everybody would still have the patience to listen to me for 1 or 2 or 3 minutes. We have extended this sessions every time because discussion has become so interesting that people forget about the dinner. They want to have this kind of appetite for the knowledge, and I must thank everyone for staying on. In fact, the very next session at 9 o'clock in India is going to be on the subject of innovations in dispute resolution mechanism in investment treaty arbitration. So this is going to be extended. We have some finest speakers, but you may have to miss your dinner bit, or along with the dinner, you can do it. Number 2, there are a few points very quickly I will make. And on Monday, I'm going to be speaking on one world, one tax idea, which I've talked to you earlier, but in a little more detail, along with Arvind Datar, our very respected senior counsel, and Puras Kaka. So it's going to be very exciting. And even after that, on Tuesday and Wednesday, and we are going to have some more. The series will end on Monday, but we are going to continue on Tuesday and perhaps on Thursday. One on negotiating tax indemnities in M&A transactions on Tuesday 5th. And number 2, I think it will be Thursday. We'll come back to you with a calendar check on that. How do you integrate intellectual property and tax aspect for global structures? So I think that would be another advanced learning for all of you. So most welcome. Now coming back to some points that have been made, reference was made to World Tax Organization. Time has come. Now we are meeting in thousands. Okay, we have big power on our side as well. If governments can come together, 130 government, we can have thousands of people come to form a World Taxpayers Organization. One guarantee we want from all the governments is that while double non-taxation may not be acceptable, but double taxation is certainly not acceptable. And saying that is one guarantee every government must give. Under no circumstances the taxpayer will be doubly taxed. Okay, and we can work around that. Also, we need to, I think we have come to a situation that there is high level of tax imperialism. So as I mentioned, that countries are encroaching on the taxing sovereignty of different countries. So I think we'll have to sort out that. And I think if we do not resolve that, we will have tax pandemic, I would say tax COVID would result, because it will create so much chaos and overlapping and unnecessary problems that will be coming into. Also, so we need to get back to the basic purpose of income tax. Why do we have income tax? And what do we do with that? How it is being applied in the context of each jurisdiction? It goes in corruption. What do you do about it? Where is accountability internationally? So, we'll have a lot of interesting questions coming up. And finally, we talk about BEPS all the time, base erosion and profit shifting, right? The entire exercise is on the procedural side. I hope the amount of time that we have spent in discussing BEPS and procedural and collection and all that thing, we should have spent so much time on what is called base without defining or even reasonably describing what is base, what is source, and what is that. We have not done that exercise in sufficient detail. That is where I would think that we have to really focus on. If we do not focus on, then each country will extend its source. Each country will get into different kind of zone and recovering force, for tax is ultimately force exaction, it's not like charity, right? And that is what is still accepted principle, because it is requiring a very high level responsibility in all governments, that you first of all impose tax, but also you have duty to give reasonable clarity to the taxpayer to, so that he can behave, and that is why we should be focusing on giving more clarity on what is base, and that is what is a source. That's what will be, I think, requiring. And therefore we are looking at now the concepts of one world, one tax and stuff like that. We say, why should we be fighting with every government? You tell us you want to put us 15%, 20% in the escrow account, we'll put it, and you governments sort out between yourself. Don't bother me more than you tell me the base, definition of base or source, and I will put money, you distribute it, somewhat like quasi GST kind of stuff. So there are a lot of interesting things that are happening, and it is, Professor Muhammad Yunus, Nobel Prize winner, always says that you create the world that you want. Okay, don't depend on governments to create the world. You create the world that you want. If we want to shape the world of the future, then we all have to come together and work towards that, get more clarity. We should help government to clarify the norms and the principles and stuff like that, but understanding that, we are all there to pay the tax if at all that is necessary, but we need a fairly reasonable clarity, if not absolute. I think that today world has moved towards ambiguous tax environment, and companies have to fight cases in 100 different countries. Everyone has his own perceptive way of taxation and stuff like that. and artificial theories are coming up. Most law, it's become so fictional. Everything is a dimming fiction, and you are writing stories upon stories and upon stories within the income tax law. So yeah, some of the things that we really need to fight for our rights, and at the same time make sure that together we all work and change the world for the better. This is what would be my concluding remark for today. So I would appreciate all of you join on Monday in the evening at 7:15. We are very good, as I mentioned, the panel, and then also continue to take forward and let us do something interesting, exciting, fruitful, and helpful, together. We have so much talent within our group, right? All of us together, thousands of people. Thank you so much.